So one of the questions we get a lot is, what is the difference between a living will and a last will and testament? Sometimes we call that a pour-over will, depending on if we have a trust involved or not. And why do we call both of them wills, and what's the difference between both of them? A living will is the physician's directive. So the living will is the document that we give to the hospital or doctor's office if you're admitted to the hospital and you're in a persistent vegetative state or a terminal condition, and you've already made the election on your living will to say whether you do or do not want to be kept on life support. And that's a form that we fill out ahead of time, that you've already made the election of, I do want to be kept on life support under any condition or circumstances, or I do not want to be kept on life support if I'm found to be in a persistent vegetative state or a terminal condition. You can also make elections such as, I just want to be kept comfortable on your living will, give me the morphine, change my sheets, moisten my lips, those kinds of things. You can make the election of whether you do or do not wish to have cardiopulmonary resuscitation, for example, the use of drugs, electric shock to bring you back to life. If you're in a persistent vegetative state or a terminal condition, your heart should stop. You can make an election of whether you want artificially administered food or fluids if you're in a persistent vegetative state or terminal condition. And you can make an election of whether you would prefer not to be taken to the hospital and rather stay at home and have in-home hospice care or in-home care come in. And so that's your living will, your physician's directive that does all those things. And your estate planning attorney should help you fill that out, help you make the selections that you want to take care of all those needs. One of the famous cases we hear a lot about is the Terri Schiavo case out of Florida, where she didn't have a living will, and so her husband and her parents argued about what should happen with her now that she was in this persistent vegetative state. And the husband, of course, was arguing that she should be removed from life support, and the parents of Terri were saying that she should be kept on life support. And because she didn't have this one legal document, a living will in place, we ended up fighting and spending lots of time and money and energy and court fees arguing about whether Terri should be kept on life support or not. Had she had the living will in place and she had made the elections that she wanted while she was alive and had capacity, then we wouldn't have been fighting about that. So that's your living will. Deals with persistent vegetative state, terminal condition issues. Whereas your last will and testament, or your pour-over will, is a legal document that says, when I die, this is who gets my stuff upon my passing. Now, if you have a trust in place and all of your assets are in the name of your trust, then your trust document controls where your assets go upon your death, not your will. And so if you have a trust, we're not utilizing a last will and testament. You might also have something called a pour-over will that's part of your trust. That document is in there just to say, if you screw up and you leave something outside of your trust that you should have put into the name of the trust while you were alive, then the pour-over will's job is to grab that asset upon your death and pour the asset into the trust now that you've passed away. But if we're using a will to gain control of assets, it means two things have happened. You've died, and the asset was just in your name. There was no beneficiary, it was not in the name of your trust, there was no joint ownership on the asset, and now we got to use your will to open probate to gain control of the asset now that you've passed away. So we usually don't want to be using wills for the most part. We would rather utilize a trust and have the trust own everything, and that way we don't have to worry about probate upon death. So that's the difference between a living will and a last will and testament. Living will is health issues, incapacity, persistent vegetative state issues, and your last will and testament is dealing with assets upon your death. Hopefully that helps.